Good morning, hello, and welcome. My name is Alison from the Federation of Small Businesses, and I'm your host today. Thank you for joining us on what also happens to be Data Protection Day. As part of our commitment to supporting small businesses with practical expert-led guidance, we are proud to host today's webinar in collaboration with the Information Commissioner's Office, the ICO, the UK's independent regulator for data protection. The ICO works with thousands of small businesses and sole traders every year, offering support through their business advice helpline, live chat, and a wide range of online resources tailored to small organisations. Today, they'll be sharing a beginner's guide to subject access requests, SARs, one of the most common data protection topics small businesses ask about. You'll hear practical advice and tips to help you understand what a SAR is and what rights individuals have, the simple steps to follow when you receive a SAR, common challenges small businesses face when handling SARs, and how to plan ahead and stay compliant. Please use the Q&A button to send over your questions. We'll aim to answer as many as we can during the session, including those submitted in advance. We have had a huge amount of questions in advance, so we'll not be able to get through them all. For specific subject access request guidance, please do contact the ICO's helpline. If you ever have any questions about data protection, don't forget that FSB members can contact our legal advice line for initial guidance. We can also help direct you to the ICO's specialist resources and services for small businesses. After the session, we'll share the recording of today's webinar and links to some of FSB and the ICO's most helpful tools and guides designed to help you put data protection into practice confidently and effectively. So before we hand over to the ICO, we've got Adam Grimwood with us from our FSB legal advice team, and Adam is going to give you a brief introduction to data protection.
Thank you, Alison. Good morning, everybody. My name is Adam Grimwood, and I'm one of the solicitors here at Markel Law. Hopefully, most of you will be aware that the FSB and Markel have a long-standing relationship, and FSB members have access to Markel services and resources as a right of membership. Markel provide legal advice to FSB members on a wide range of matters, both over the telephone and via the FSB legal helpline, which is always staffed by fully qualified lawyers, and online via the FSB Legal and Business Hub. We advise upon all areas of the law, including all legal and business matters, employment law, tax and VAT, debt recovery, health and safety, and of course, today's subject, data protection and GDPR. Now, there's lots of guidance on the Hub about this topic, as well as various useful templates for you to use to make sure you're compliant with this area of the law. Before I hand over to the ICO, I do want to give you a very brief overview about data protection generally to help set the scene and to set out certain key aspects of what it means in practice for your business. And these are the sort of things we get asked regularly on the legal advice line by FSB members. So what is data protection? Basically, data protection involves having certain policies and procedures in place so that your business protects information which you hold about people. Your duties and obligations last throughout the entire time for which you hold the data, from collection to processing to storage and deletion. The information you hold can relate to your customers, suppliers, staff if you have them, or anyone who comes across you in the course of your business. The types of personal data you hold could be anything, including names, addresses, contact details, email addresses, records, correspondence, notes, payment details, or any other details. And you may hold this data on various different mediums. For example, CCTV recordings if you're using CCTV on your business premises, or dash cam recordings on your business vehicles. The key aspects of data protection include data security, which means you have to have measures in place to prevent any unauthorized access and use to any data you hold about people, and data privacy, which involves having procedures in place to ensure that any information that you hold about people is processed fairly, lawfully, and only for specific legitimate purposes, and all the time you're respecting individuals' rights in line with data protection laws, including UK GDPR. So what is data protection law? Why does it exist? Basically, data protection law refers to the rules and regulations that require you as a business owner or employer to handle people's data and personal information responsibly. The main pieces of legislation in the UK are the UK GDPR and the Data Protection Act 2018. And these laws are there to protect people's rights with regard to their personal information. Your customers, employees, and any others you deal with will expect transparency and fairness in terms of how their data is processed and stored. And at its core, data protection law is about protecting the rights people have with regard to their information. Data protection also builds public trust, and customers and suppliers are much more likely to deal with businesses and organisations that treat their data with care. As such, having good data protection compliance and procedures can boost the growth of your business as well. All businesses have to comply with data protection law no matter what size they are or what industry they're in. As well as the possibility of significant fines for breaches, you can also, of course, be taken to court by any individuals who are adversely affected by any failings on your part. So what does data protection compliance look like in practice for businesses? To help you comply with UK GDPR and data protection law generally, one of the best places to start is with the ICO's handy step-by-step guide to getting started with data protection, which is on their website. It includes useful links to relevant advice and tips to help you understand what you need to do. As I've stated before, there's also plenty of useful guidance and precedent documents for you to use on the FSB Legal and Business Hub. To give you a very quick outline of what data protection compliance means in practice, it's things like, number one, only collect information that you actually need, and you shouldn't be asking for any information or keeping information just in case. Secondly, you must have a fair and lawful reason for any personal data that you either have or use. And this means you should only use people's personal data in ways that they would reasonably expect. For example, if you have a customer's telephone number to arrange a delivery, it wouldn't be fair to use that number to call them for personal reasons, and they also wouldn't expect you to do that. Thirdly, have clear and valid reasons for processing people's personal data, known as lawful bases. There are 6 types of lawful bases which you can use, and you'll find information about these both on the FSB Hub and on the ICO website. Fourthly, you need to take steps to protect people's information, and this means making sure that you have robust security measures in place that are consistent with the level of sensitivity of the personal information you hold. Fifthly, tell people, such as your customers and staff, why you need their data, who you'll share it with, and how long you'll keep it for. This is usually done via a clearly worded privacy notice, or sometimes called a privacy statement or policy. Again, there are precedents available on the hub, as well as an extremely useful tool to help you generate your own privacy notice on the ICO website. Number 6, have procedures in place to respond to people's data protection rights quickly. For example, if someone asks you to delete their data, change the accuracy of it, or objects to what you're doing with it. People can also ask you to provide a copy of their personal information, which is known as a subject access request or SAR, and which is what the FSB are going to, sorry, the ICO rather, are going to talk to you about once I've finished. Number 7, you do need to know how to handle data breaches. If any personal data which you are responsible is lost, accidentally destroyed, altered without proper permission, damaged or disclosed to someone it shouldn't have been, this could and is likely to be a personal data breach. It might be the result of many things, including a cyber attack, or theft, fire, flood, or human error. And when this happens, you do need to act quickly. You may need to report it to the ICO within 72 hours. So it's important to have processes in place to avoid these breaches, but also to know how to handle them if and when they happen. Number 8, check if you need to pay the data protection fee, because it is a legal requirement to be registered and to pay the relevant fee unless you're exempt. And there is a useful fee checker tool on the ICO website to understand if you need to pay and how much, or whether you are in fact exempt. And lastly, if you have staff, it's important to train them on how to keep data safe and to spot risks. So that's really all from me. That's a brief whistle-stop tour of data protection and the law. And with that, I'll ask the ICO to take over and talk to you specifically about subject access requests, which of course is a topic which both the FSB and the ICO get lots of questions about on a regular basis. Thanks.
Thanks, Adam, and hello everyone, and happy Data Protection Day. As mentioned, we're going to be looking at subject access requests today. What subject access requests are and what to do if you get one. Subject access requests, or SARs as we'll mostly refer to them today for ease, are one of the most common topics we get questions about. And our aim for today is to give you practical guidance on how to recognise and process a request. But before we go any further, let's just introduce ourselves properly. So as has already been said, we are from the Information Commissioner's Office, or ICO for short. That's the UK's independent regulator for data protection. Our job is to uphold information rights, including data protection and freedom of information laws. And in our department, we support organisations of all sizes to comply with data protection law. So my name is Rob Cole, and I've worked at the ICO for over 20 years. I'm currently a Senior Engagement and Policy Officer in our Business Advice Services, or BAS for short. And as the name Business Advice would suggest, our team's role is to provide legislative advice to organisations of all types and sizes. I have with me today my colleagues Zach and Jesse, who will take you through today's presentation. Zach and Jesse also both work in Business Advice Services, and as I say, their main roles are to act as a point of contact and provide advice to organisations like yours of all shapes and sizes, and they do that through our helpline and live chat and written inquiry services. Just one more thing to add. At the end of the presentation, I'll be sharing a slide with a QR code on, which takes you to a very quick 2-minute feedback survey. I wouldn't normally encourage people to have their phones out during a presentation, as obviously we want your full attention. But on this occasion, I will ask you to get your phones ready now, so you're prepared to be able to scan the QR code at the end, because we really would like as much feedback as we can to improve these presentations and do more as we go forward. And now we've got that out of the way, over to Zach to get us started.
Cool. Hi everyone, thanks very much for that, Rob. So before we get into it, I'll just give you a very quick overview for the session. So what we're going to be looking at today is we're going to be starting off with the SAR basics, looking at how to prepare and receiving a SAR, sending a response, and then we'll look at some of our useful resources, and then we'll have a roundup and some questions at the end there. So if we want to get started, the first section that we'll be looking at today is the SAR basics. So what is a SAR? Simply put, a SAR, or as has been said before, a subject access request, is a request from an individual to access their personal data held by your organisation. It's one of the individual rights under the UK GDPR and Data Protection Act 2018, which gives individuals the right to know if you process their data and then access that data and provide supplementary information. SARs are a cornerstone of transparency and accountability, which are important data protection principles. As an organisation, you must be able to recognise those SARs, whether they come from employees, customers, or even service users, and then be able to respond to them promptly. This matters because a failure to comply with SAR obligations can lead to complaints, enforcement action, or reputational damage. So moving on, we'll look at who can make a SAR and how. Now, any individual whose personal data that you process can make a SAR. This may be current or ex-employees, customers, clients, or service users. So simply put, if you process their data, they can make a SAR. These requests can come in many forms. They could be submitted in writing, verbally, via portals, or other websites, even via social media. We've already said that a SAR can be written or verbal, but another important thing to know is that requests don't have to refer to the UK GDPR or even use the term subject access request, SAR or DSAR. It just needs to request their own personal data in some way. So you'll need to make sure that you train your staff to be able to spot those SARs in those emails, letters, calls, and across social media. So you should look for phrases such as, I want to see my data, or please send me all the information that you hold about me. Now, sometimes people will accidentally call it an FOI, or Freedom of Information request. This is a totally different set of legislation and a totally different type of request. If you're not a public authority and the information requested is for their own personal data, then they're likely referring to a SAR. You can't insist on people using any sort of specific form to make a request, but you can still provide one for people to use if they want. We do have a template on our website that you can use if you'd like. And just keep in mind that you might receive a SAR from a third party, such as a legal representative or maybe a relative, such as a parent. This is perfectly fine, so long as they have the proper consent to act on their behalf. For example, something like written authority signed by that individual confirming this third party has their permission to act on their behalf. Okay. And so moving on again, how long do you have to respond? Well, the normal time frame for a response is within 1 calendar month of receipt. It doesn't matter if the day that you receive a request isn't a working day. If the SAR's due date, though, falls on a weekend or public holiday, you have until the next working day to respond to that request. Now, sometimes a request will be complex. In these cases, you can extend the time frame for a maximum of 2 additional months to the 1 month you already have. You can also extend the time frame if you get multiple requests from the same individual in a short space of time. If you do extend that time frame, you must notify the requester as soon as possible within that first month. Don't leave it until the day before they're expecting a response to tell them this. Now, Jesse will be talking in a little bit more detail a bit later on about verifying someone's identity, but simply put, if you need to take steps to verify the identity of that requester, then the clock starts when you have enough information to do so. The same applies when you're awaiting confirmation of authority, where the request has come from a third party, like we mentioned earlier. So, looking next at how to prepare for a SAR. Now, the main thing to think about here is to not panic. SARs are completely manageable with preparation. The key things are to make sure that you can identify a SAR quickly, be clear in your communication with the requester, and then document those decisions in your log. You should, for example, have organizational measures in place that can help you to easily find information. For example, physical ways you can do it is the way you name files or label emails. They can make it easy for you to find exactly what you're looking for. So plan ahead by mapping those data storage locations, but that's just a fancy way of saying make sure you've got a list of where things are kept, and then ensure those systems allow fast and accurate data retrieval. As an example, for your staff, you may have things like HR files, email, performance reviews, and for things like your customers, you may have customer files, complaints records. So just make a list of what data you hold and then tick them off as you go. Now, you should have a process and procedure in place to deal with those SARs. Having this will help you prepare and handle your requests in a timely manner. Last but not least, but make sure you train your staff regularly. So make sure that they understand the SARs procedure and where to go for help if they need it. You can also use templates for responses to help streamline that process. So we do get quite a lot of common challenges come up by manning the helpline to organizations. Now, the first of these that come up quite often is trying to manage large volumes of data. Now, for example, we get calls where a search for someone's name has returned hundreds or even thousands of emails. To help you deal with requests where you hold a large amount of personal data, you can ask the requester for more information to help you locate that information that they want. For example, if they're looking for data from a particular time period, can they give you those dates that will let you easily search for the information? Of course, if they say no, you'll still have to carry out what we call reasonable searches, but you should explain to them that by clarifying their request, you would be able to focus your searches on locating the specific information they want, meaning you may get the information to them quicker. Now, having a good retention policy also helps when it comes to handling those subject access requests. It helps to make sure that you're only keeping the data that you need and means that there's less information for you to search through. And managing data sets that contain both personal and business information can cause complications. But just remember that a SAR is only for personal information, not business data. So as an example, emails that have been sent by an employee, but it's to do with their work, is unlikely to be their personal data. And repeated SARs or grievance-related SARs is quite a common theme where you get repeated SARs. So, if it feels like you've not responded adequately to someone the first time when they've made a SAR, they may very well put in another request. It's also quite common for employees or customers with grievances to put in many SARs there. But that's all from me, so I'll be passing it over to my colleague Jessie now to look at the next section of our slides.
Hi everyone, so the next thing we're going to look at is what to do once you actually receive a SAR, starting with verifying someone's identity. So as I've said, the first step now you've had a SAR through is to confirm you know who the requester is. So in essence, are they who they say they are? Sometimes it'll be clear and obvious. It might be an ex-employee who sent a request via an email you have on file, and the request makes sense in the context of the job that they did. Where it isn't clear, you can ask for additional information such as ID. It's really important that you keep the request reasonable and proportionate and you don't use it as a delaying tactic. And so by reasonable, we mean you shouldn't do things like ask for photo ID when you have no idea what the person looks like, but you can ask for information that is necessary to confirm someone's identity. If you have to ask for additional details, then you should make this clear to the requester and explain that the SAR clock pauses until the ID is provided, and this helps to prevent delays and misunderstandings. Something to be aware of when gathering the information for a SAR is exemptions. Sometimes there'll be information that isn't appropriate to share with the person, even though it is their personal data. And in these circumstances, you can apply an exemption as long as the information fits the criteria. And there are several different types of exemptions. One of the most common ones is the third-party data exemption. This is also known as protecting the rights of others. This is where there's information about other people as well as the requester. And you should use a third-step process when looking at this data or deciding whether to share or whether to withhold. So the first is to redact the third-party data where you can. If you can't redact or it still be obvious who the third party is, then you should consider asking for their consent to share. And lastly, if you can't ask for consent, you will need to make the decision whether to share the data. So if your instincts tell you that this data shouldn't be disclosed, listen to them. Why do you think this would be unreasonable to share? And would the third party expect their data to be disclosed? Documenting your reasoning and consider if it is enough to be compelling justification for withholding the personal data. So there's no legal trickery here. It's deciding whether or not to disclose can be common sense and it's very context specific. We say that you're in the best position to decide whether to redact or not, but if you're not sure, call us because we're here to help. On the other side of the slide are some other common exemptions. There are more than this, and you can find a full list on our website, along with an explanation on how each exemption works. But just as an example, we have legal privilege, management forecasting, so for example, that's making redundancy plans, and confidential references. If you do use an exemption, you must be able to justify your reason for withholding the personal data, and you'll need to document it in an internal SAR log. Next, we're going to look at refusing a subject access request. One of our most frequently asked questions is whether a request can be refused because it's manifestly unfounded or excessive. And refusing a subject access request on these grounds is a high bar to reach, so you'll need a strong justification, which you should document. If it's clear someone doesn't intend to exercise their right of access, this could be manifestly unfounded. For example, someone making a request but then offering to withdraw it in return for some sort of benefit, like a reduction in their rent or cancellation of a fee. It could also be manifestly unfounded if the request is malicious, so that is, if it's being used to harass your business with no real purpose other than to cause disruption. A request might be manifestly excessive if it is clearly and obviously unreasonable. Before refusing a SAR as excessive, you should take into account all of the circumstances around the request. For example, the nature of the requested information, your available resources, and whether you have already provided the information. The word manifestly means that there must be an obvious or clear quality to it being unfounded or excessive. Now, if you do refuse the SAR, then you can offer to complete the request for a reasonable admin fee. This fee should only cover the cost of things such as printing, photocopying, postage, and finding the relevant information. So next, we're going to move on to sending a subject access request. And we're looking at what to provide, so in terms of personal data. So once you're confident that the subject access request is valid, you must take the necessary steps to find the personal data they're entitled to. I know this is often the hardest and most time-consuming part of the process for organisations. And the key to getting this right is understanding what personal data is and which types you hold. Now, this will vary depending on who is making the request. For example, you'll hold different types of data for a staff member than you would for a customer. Any information that identifies or makes an individual identifiable will be their personal data. So this includes things like names and information that relates to them, such as addresses. A commonly asked question is, we found hundreds of emails, do we need to provide a copy of each one? And the answer is always, it depends. So you should look at the content of the email and ask yourself whether the email is about them and does it relate to them in any way. If so, you'll need to send a copy of the personal information in the email. And this actually brings me to a useful point. So you don't have to send a copy of original documents in a subject access request response. You just have to provide a copy of the personal information held. So you could choose to send a document and redact it as appropriate, or you could copy and paste information into a clean document and then provide the context so that the information makes sense. Now, remember, as Zach said, the legislation requires you to do a reasonable search for the information. If the request isn't clear or you're having trouble locating information, don't be afraid to ask the requester for more information. And if you're not sure on something, you can always use our website or contact us for advice. Once you've gathered the information, you'll need to check if any exemptions apply, like I mentioned on the previous slide. And as well as sending across the personal data, you'll also need to provide some supplementary information. This is just information about why and how you process their personal data. It can normally be taken from your privacy policy, and there's 4 main points to it. So the first is the purpose of processing. So why are you processing their personal data? The categories of data, so is it the name, address, and contact details, or do you have any special categories of information such as race or health data? Who the data has been shared with, if you do share it with any other organisations, and your retention period. So the retention period is how long you keep someone's personal data for, and you might have different retention periods for different types of data. Also in your response, you need to provide contact details for complaints as well as contact details for the ICO. This is because individuals have the right to complain to you if they're unhappy with the SAR response, and then they also have the right to complain to us, but we ask them to give you a chance to respond before taking that step. So now we're going to look at how to send a subject access request response and the next steps to take. So you need to provide the SAR response in a commonly used format, so for example, as a PDF. Most of the time, requests will come in by email and you can reply by email. And you must also make sure that the data is shared securely. As part of the process, you'll need to maintain an internal SAR log. We've touched on this briefly throughout the presentation. When dealing with SARs, you should keep a good internal log that includes all your decision making and reasonings. And this log would be useful if people do make a complaint to you and to the ICO, because it helps you see what steps you've taken. While we spoke about responding to complaints on the previous slide, it is important to mention that the introduction of the Data Use and Access Act brings in a requirement to have a complaints process. The intent is to encourage organisations to resolve complaints at an earlier stage and reduce the number of formal complaints received to the ICO. So this change actually isn't in force yet, but in brief, the new provisions will be a new section of the Data Protection Act, and they'll require organisations to allow people to make complaints. You'd need to then acknowledge that receipt of complaint within 30 days, make appropriate inquiries without undue delay, keep the complainant informed about the progress, and give a final response without undue delay. Now, we actually have some really useful resources on here at the ICO to help you when you're going through subject access requests. We have the SME Hub on our website, and you can scan the QR code to access it. In our main organisation section, we also have detailed guidance on subject access requests. We have explainer videos on our YouTube channel, and we have our helpline and live chat services as well. And also just to point out that we do have the web address at the bottom, so it's ico.org.uk/SME. It's worth regularly reviewing our resources to stay up to date with any changes. So for example, some of our SAR guidance was recently updated to reflect the changes in the Data Use and Access Act, also known as DUA. And now I'm going to pass back over to Rob.
Hi, thanks for that, Jessie. Just before we move on to questions, this is the slide that I mentioned earlier with the QR code. So if you want to give us any feedback on the presentation today, please do feel free to scan that. Just hover your phone over it and it should be able to scan it. And we would love your feedback as it gives us a chance to improve these presentations or change them and answer questions that you need us to answer. Which, talking of questions, are we going to move on to questions now?
Thank you, Rob. Yes, we have lots of great questions sent ahead of the webinar and coming through on the feed. So let's start to answer these, and we'll get to as many of them as we can in the time that we have. So kicking off, it's a question for Adam. What are the repercussions for an organisation if they don't send all information they hold on a person?
Right. So yeah, as it's being touched upon, obviously you're expected to carry out reasonable and proportionate searches. If something is missed, and the ICO are here, so they'll correct me if I'm wrong, the ICO's usual approach, especially with SMEs, is to try and help the business understand what's required and work with them to fix it. So if an individual does then complain in these circumstances, the ICO may look into it and whether the searches were appropriate, whether anything further needs to be provided. But usually formal action from the ICO in terms of sanctions is generally reserved for situations where organisations repeatedly ignore their responsibilities or refuse to engage. So, you know, that there also can be risks if someone suffers actual harm, but in most everyday SAR situations, issues can be resolved through clearer communication and correcting any gaps. But I suppose ultimately, in terms of repercussions, hypothetically, there's always the risk that the individual who suffered harm, and that can include distress, can potentially bring a legal claim through the courts, but most cases don't reach that point. And obviously, the key thing is to do what you can to try and avoid these things happening and to deal with them swiftly and professional, and using the advice and the support that you've got here to hopefully handle them correctly.
Lovely. Thank you, Adam. The next question is for Zach at the ICO. To what extent do you have to provide internal messages about a customer, for example, from a CRM system, especially if the messages are a summary of a recorded call already being shared?
Well, thank you. So as I touched on earlier in the slides there, you only need to provide the personal data in response to a SAR. So in this situation, it does depend on what those internal messages actually are. But as we mentioned in the presentation, if they relate to and identify an individual, then it's likely that would be personal data that would need to be given. Now, I'm presuming that the call recording as part of this is being provided as part of a SAR. If that is the case and the personal data is the summary, if the personal data in the summary is exactly the same as that call recording, then you likely would not need to provide both as part of that same SAR. However, something to think about is if that call summary contains additional personal information or would provide further context to the personal information, then you may also have to provide that as well.
Lovely. Thank you, Zach. Adam, the next question I think is back to you. The question, I would like to request information about my exam that I've taken twice. It is not asking for feedback, but would like to know how the information on my attempt.
Right. So yeah, again, so obviously you do have the right to access personal information about you. And in the context of examination specifically, this does generally include your exam score, any sort of administrative records about your attempts, your attempts to pass the exam, and any decisions made about the eligibility, your eligibility, or the outcome, the mark that you've got. So that's the sort of information you're entitled to. You're not, technically speaking, necessarily entitled to your exam scripts, that is to say, your written answers. These are not normally disclosable as personal data based on what my understanding is long-standing ICO guidance, and organisations don't have to create any new feedback. So the feedback that's captured at the time, that's what it is. They don't have to elaborate to you or provide any further explanation as to why you haven't passed.
Lovely. Thank you, Adam. Jessie, over to you now. As a lender, we have a regulatory obligation to send a wide range of letters and annual statements to customers in arrears. Do we have an obligation to send copies of all the letters? And in most cases, these can span over several years, if not decades, as part of the DSAR, given that these would have previously been sent to the customer.
Thank you. Okay, so the first question to ask yourself in these situations is whether the content of the letters is the personal data of the requester. So if it is, then that information would be in scope, even if you've provided it before other than as part of a SAR. So for example, statements would be considered personal data as they reveal someone's financial information, so they would fall within the scope. In some cases, you might be able to collate the information in response to the SAR for it. So, for example, if you sent 16 letters warning the customer that they're in arrears and the letters are identical just on different dates, then in response to the SAR for that information, you could provide one copy of the letter and then list the dates that the letter was provided. And a good practical approach actually might be to ask the requester if they want copies or not. That way, you're not bombarding them with information that they didn't need, and it can also save you time if they don't want it.
Great, that's lovely, Jessie. Thank you so much. There's a question here. I think it's for Adam, and it's but you may want to leave this one until the end, until there's time. We're talking about the PECR here. I've asked I have been asked to unsubscribe from a newsletter 5 times over 2 months, or I have asked to unsubscribe, I beg your pardon, from a newsletter 5 times over 2 months and send the company an email asking them to take me off their list. What's the best way to proceed to get them to remove me if they are ignoring my requests?
Yeah, right. This is something we do frequently get asked on the advice lines. It is a little bit off topic, but obviously it applies to the person asking and also for the businesses that are potentially doing this sort of direct marketing, which obviously is an increasingly common thing. So as an individual, you absolutely do have the right to request direct marketing to stop, and you should expect that to happen. And you need to effectively, if you've done this, you need to contact them again directly, specifically stating in writing that you're exercising your legal right to object and that you want to be placed on their suppression list. And if they still ignore you, you can report this to the ICO, who again can look into it and help resolve the issue. Obviously, it's then up to them as to how seriously they treat it. Formal enforcement is possible, but as we said throughout, the ICO will, generally speaking, try to work in a collaborative way where possible. And just a useful tip for any sort of individuals, including businesses, that don't want to receive any junk mail or unsolicited phone calls, you can register for free with organisations like the Telephone Preference Service. And there's a corporate one as well, and the mailing preference service, which hopefully makes it even more unlikely that you get contacted in that way, and increases the potential sanctions for someone who doesn't bother sort of cleansing their data list against that so as not to contact you in the first place.
Yeah, indeed. Thank you. Thank you, Adam. That's quite a common question. Sticking with you, another question here. I requested a SAR. It was ignored. What would the next steps be?
I mean, obviously, you do try and escalate these things in a sort of logically progressive way. So, first of all, you would go back to the organisation again and try and remind them. It might simply have been missed. There can be human errors or things get overlooked. But again, if nothing happens, then it's back to our friends at the ICO, I would suggest. And again, they will look into it and with their sort of problem-solving approach. Basically trying to help the organization in question fulfill your request, not initially looking to jump on them and punish them if at all possible, but just trying to help them to help you get what you're looking for.
Yeah.
Look, if ultimately it wasn't forthcoming, then as I've alluded to before, in principle, there's the possibility of bringing a court claim, but you'd be looking at what sort of distress and harm you'd suffered, and then, as with any legal action, you're always having to weigh up the cost benefit and the stress levels and the time it will take to proceed and those sort of issues.
Yeah, fantastic. Thank you. It's just sticking with you for a moment, if we may. How do we balance data erasure requests with legal and regulatory responsibilities? So, for example, as an e-commerce company is asking, as an e-commerce company charging VAT on orders and the requirements to know your customer on an invoice and retain that information for 6 years, or as a marketing agency running a promotion in accordance with CAP code regulations, if an entrant's data is erased, and how do we ensure the rules of entry remain compliant and fair for all, particularly on those promotions running beyond the calendar month response window? Well, something to unpick there, really.
Right, yes, it's a long question. No, thank you for that. Yeah, I mean, often with data protection, there does feel like there's sometimes these sort of conflicts between certain principles, and those can be tricky. I think, as we're saying throughout, if ever you're any doubt about any particular issue, do ring the advice lines. What I would say is that if you do have a legal obligation to retain information, for example, HMRC requirements regarding VAT, got to hold on to records for 6 years and so on, then you don't have to erase that data. And instead, what you probably should be doing is explaining to the individual, being open and transparent and clear, explaining why you have a legal obligation to keep hold of that information, but making it clear that you will delete any other information that is superfluous. And that approach is fully allowed under UK GDPR. So, I mean, for things like promotions and competitions, which you're asking there, I think, you should be looking to erase personal data once it's no longer needed to run the promotion fairly and to meet any regulatory requirements. Until you've done that, you keep what's necessary and delete the rest. And once the information doesn't serve any meaningful purpose, then on the face of it, you haven't got a justification to hold on to it anymore.
Yeah, absolutely. And again, with you, can you please advise on redacting of members' names when responding to a SAR about a pupil within a school, please?
Right. Yes. Okay. Yeah. I mean, data protection always feels a little bit more sort of sensitive, as often when in a sort of school setting when you're dealing with pupils, young people, and often sort of disciplinary issues and stuff like that. So, I mean, look, you only need to provide the pupil's personal data. So, if including a staff member's name would reveal that staff member's personal data, then you do need to consider whether it should be redacted or disclosed, because it is ultimately third-party information. I mean, what that means in practice really is that, I mean, staff names should usually be redacted when the staff member is mentioned only incidentally, so it's not particularly massively relevant, or when the information in question sort of relates more primarily to the staff member themselves rather than to the data subject, so the pupil, for example. So if the information relates more to the staff member, for example, their HR records or performance reviews or sensitive allegations, then that sort of thing, because it's more linked to the member of staff than the pupil, that on the face of it should normally be redacted. But as a general rule of thumb, you wouldn't normally redact staff names when it's more a question that they're sort of just going about what you would expect to be their day job, so to speak. So if the staff member is mentioned because they have created information that relates to that pupil's educational record, for example, reports, assessments, or pastoral notes, those are going to potentially name the teacher, the member of staff who's created them, and so that wouldn't normally need to be redacted. So basically, whenever the staff member is acting in their professional capacity connected to the pupil's educational welfare, then you would normally expect you don't need to redact that information. If anything, the pupil and the staff member in the school, everyone knows who the person is in that context anyway. So you've got to always weigh it up against what's fair and reasonable, and make sure that your decisions are consistent and justifiable. But again, with specific ones like that, I think it's always a good idea to ring the advice lines that we both operate.
Indeed. Thank you for that, Adam. Rob, over to the ICO. How does an organisation manage SAR requests when personal, i.e. non-corporate, devices are involved, noting a lack of policy that covers personal device use in an organisation?
Thanks, Alison. A slightly tricky one, because I note in the question they mention that there's no policy. That would be a key thing, really, in the first instance. But I'll get to that in a second. I mean, generally, we would say try and avoid using personal devices to process work-based personal data if possible. Really, due to the sort of logistical and practical problems that the data controller literally being able to control that data. Obviously, if it's on someone's personal device, it's going to be difficult for them to control that data in any sense. But if you have to use personal devices and it's unavoidable, you should have a practical policy and process in place, really, that everyone knows about and agrees to, so that the data controller knows what's being processed and by whom and where. Like we mentioned in the presentation, and most importantly, that they can access it, and also everyone knows what they should or shouldn't do and what personal data should be processed, and shouldn't. If none of that is in place, though, I guess the data controller is just going to have to try and do their best to access the data if they've received a subject access request. But going forward, I think they should look to put policies and procedures in place to deal with that situation if they have to use personal devices. From a practical point of view, though, and if this is a real situation you're struggling with at the moment, you can always ring our business advice helpline and talk it through with one of our team. We'll be able to give you, get the details and give you some more practical advice, probably.
Yeah, thanks, Rob. Jessie, How should a small business deal with an excessive request in a SAR?
Oh, sorry, go on.
No, I was
Yeah.
just going to go on, over to you.
So a request isn't excessive just because it asks for a lot of information. So for example, if someone sends a email request saying they want access to all emails between a group of colleagues, that wouldn't in itself make the request excessive. So with requests like that, you just need to remember that the request is only entitled to their own personal information. So is what they're asking for actually their personal information? And also, this is where being prepared to receive a SAR can help. So, as we mentioned in the presentation, it's worth checking your email and messaging systems. What are your retention policies? Will you still hold the data that they're asking for? And things like, can you search mailboxes by specific search terms? So, knowing what your capabilities are in advance can actually help speed up the process and remove a lot of the stress. And then the other thing to remember is that you're only expected to make a reasonable search for the information. And as every organisation is different, obviously this is going to be different for lots of people, and you'll need to work out what is reasonable for you. And by this, I mean looking at things like the volume of information you need to search to be able to respond, any difficulties that you might have in retrieving the information. And basically, you just need to be able to demonstrate like what is reasonable to you.
Yeah, that's lovely. Thank you very much, Jessie. Back to you, Adam. What should we say when a customer has purchased from us, wants us to delete their information, as they say, mindful that they have to keep the information for HMRC accounting reasons?
Yeah, again, I suppose it's a question of explaining clearly that UK law does require you to keep certain accounting records for a set period, which, as we said, is normally 6 years, and that does ultimately override the data subject's right to erasure. So you should delete any information that you don't need for that purpose. You can only hold on to the information that you do have a legitimate justification to. So if it is literally that information that is needed for tax reasons, that's fine. And again, you should always try and be open and transparent about explaining that to the data subject.
Great, thank you. Zach, is there a good way to manage SARs generated by ChatGPT or other AI generated requests?
Thank you. So yeah, I think the first thing to say when it comes to like SARs made by AI in some way, shape, or form is that it doesn't make them any less valid automatically just because they're made by AI. So requests where an individual's used like ChatGPT or another AI service should still be treated like any other SAR and consider all the things that we've talked about in our presentation when you're assessing it. So obviously things like their ID or proper authentication should be requested if needed, and also consider if you actually understand what's being asked for or whether you need to seek further clarification and pause the clock at the same time. This is because AI requests tend to be quite large and all-encompassing and use quite complex language than if an individual had written it themselves. So if you seek that clarification and the person then doesn't clarify, then as Jessie was mentioning there, conduct your reasonable searches to find what information you can and then supply it in a clear format back to that requester once you're sure you don't hold any more of their personal data. But again, I reiterate, the important thing to not forget is that it's still a valid SAR request and not discount it, even if it sounds AI generated.
Lovely. Thank you, Zach. Rob, question for you. I run a small business and work with associates. So I could get a SAR from a client, someone involved with or belonging to one of the client organisations, or an associate who is or has a contract with me. Are there any differences between the rights?
Thanks, Alison. The simple answer is no, there is no difference between the rights. But probably to understand it better, the reason is because the right to make a subject access request is only an individual's right and only applies to any personal data about an individual that a data controller may be processing. So in the situation described in this question, I think you'd make sure that the requests received are from an individual for the personal data that you're processing about them, rather than, say, from a limited company asking for business data. You could comply with that request, but it wouldn't be a subject access request if it was from a limited company asking for business data.
Yeah, okay. And Adam, when providing the information back to the requester, what format is it acceptable to provide?
You've got to provide the information in a commonly used electronic format unless the requester asks for something else. So generally speaking, PDFs, Words, or any other sort of secure electronic files are acceptable. But paper is also fine if appropriate, or certainly if they request for it in paper. But the key thing is it's got to be accessible, readable, and secure. Those are the main things.
Lovely. And just sticking with you, another question here. What factors should be considered when determining when it is reasonable not to obtain consent from a third party whose personal data would be disclosed under a SAR? So, for example, if a record contains correspondence between the data subject and a third party, would the appropriate measure be to redact the third party name, obtain consent, or deem it reasonable not to obtain consent? And do you still need to provide printed or electronic copies of all documents to the individuals who have submitted a SAR, or is it now enough to categorise the information held and why? Again, there's a lot packed into that question.
Yeah, but it is a very good question, and I think it's one that causes a lot of confusion for everybody, not least myself, really, as to which to apply first. So I always think you try and break it down into three stages, really. So firstly, you've got to ask yourself whether this third-party information should be disclosed at all. So you start by looking at whether that disclosure would be fair and lawful to the third party. So the ICO guidance says you look at things like, is that third party information likely to be already known to the person requesting? Is the third party acting in a professional capacity, in which case the disclosure is likely to be reasonable? And also, would disclosing the identity of the third party cause any harm or be intrusive or unfair? So you ask yourself that first of all. If your conclusion is that disclosure seems reasonable, then the second step is that you decide whether consent is needed and whether it's realistic to obtain that. And you should only seek consent really if it's necessary and practical. It's not an automatic step. You don't always need to have consent. And you don't need to have consent if the person requesting the information already knows who the person is, if the information is routine or professional, if the impact on the third party is minimal, or whether the disclosure is in any other way reasonable. But you do need to consider seeking consent more often than not if the identity of the person is sensitive, if the disclosure is going to adversely affect the third party in any way, or if the third party is not acting in a professional capacity. And if you can't obtain consent, or if the third party refuses, you still then decide based on fairness. And if the fact that they refuse doesn't automatically mean that you redact, you've always got to look at would the disclosure be fair and reasonable.
Lovely. Adam, yeah.
Yeah.
Sorry.
Well, the third part, sorry, it's a bit of a long-winded answer, really. So you redact only if the disclosure would be unfair. So if you decide that the disclosure is unfair or inappropriate, then you redact just that third-party information, and you still provide the requester's personal data, but you've decided to redact the other information because it would be unfair or inappropriate and disproportionate and not right for that third party to have their information disclosed.
Lovely. Adam, thank you. That was a big question. But one final question, and I'm going to come to you very briefly, Adam, and then over to Rob or Zach. If you could give one piece of advice to our audience today, what would it be? Adam?
I think it's, to be aware of data protection, which you all are by being here, but not to be panicky about it. Data protection has been there a long time. The law, it didn't just come in GDPR, although there was a huge panic about it when it did. But the law's always been there, and a lot of it is quite sort of common sense. And use the resources that are available to you via the FSB and the ICO.
Lovely, thank you, Rob.
I think similar to what Adam said there, really, our top tip probably is to plan ahead for subject access requests. It will make it much quicker and easier if you get one. So, like we said today, that will involve a few key things, including make sure your staff, if you have them, recognise subject access requests, practicing good records management, and having an approach to retaining information so you're not storing excessive information. And as Adam said, if you've got any problems, contact the ICO or the FSB's helplines.
That's lovely. Well, Zach, do you have any final comments? No, that was nicely done by Rob. Thank you very much. Well, our time is up. We will be sending an email which will include information on how to contact the ICO and FSB member helpline. So any questions that we couldn't get to, apologies for that, but we will be sending an email to you with that contact information. I would just like to say that thank you very much to Marker Law and the ICO and to everyone who tuned in today, especially those who submitted questions. We do hope you found the session useful. Everyone who registered, as I said, will receive an email shortly with all the links and resources that we've mentioned, plus a video to watch again on demand. If you enjoyed the session, please consider leaving us a review. If you're not yet a member of the FSB and would like more information about our member benefits, then please do visit our website, and Layla's going to share the link for that for you, and you can explore the benefits. So just remains for me to say thank you and goodbye.